Number 80, Stega v. New York Downtown Hospital.
Good afternoon, Your Honors. My name is John Berenbaum. I represent the appellant, Dr. Janetta Stega. This case shows...
Counsel, would you like to reserve rebuttal time?
Oh, thank you. Yeah.
How much time would you like?
2 minutes.
Thank you. Please.
This case shows why the Court of Appeals has repeatedly said that absolute privilege is a limited doctrine that should be used sparingly. Here, Dr. Stega, a health researcher who's dedicated her life.
Counsel, if we go with your position here, are we in effect overruling parts of Rosenberg?
I don't think so, Your Honor.
Because I think your argument's a very good one, except you have the problem of Rosenberg in the middle of stream here. So,
No. What distinguishes this case from Rosenberg is that Rosenberg permitted the defamed party in the administrative proceedings to challenge the defamatory statements.
But we didn't say that was dispositive in the case. We had already reached that decision and then recognized that that was true.
You're saying that that's dicta. Well, I think the
way
way to, if I can...
status type, I'm sorry, it does a status type analysis of the individual rather than the process, and I don't think we ever want to go down that road. So then it would be if you have an FDA inquiry the way you do here, and it's someone who has some type of right, yes, they would only have we want to do it in terms of the proceeding, and I think that's what Rosenberg said. And I think what the difficulty to me is if you're going to say that in this type of NASD inquiry, and this is this public interest, and now you have an FDA inquiry into arguably much more serious types of issues in terms of the public, how can we not apply Rosenberg there?
Well, there are a few questions on the table, so let me see if I can start with Judge Rivera. The point about that this is not the key element of Rosenberg. I think if you take the 3 cases that this court has addressed the quasi-judicial proceeding, you can take out of that the central point that one way or another, the defamed party has a right to contest the harm done to her. And that's, and I can get into that in more depth if you need to. So I don't think it's dicta. I think it's a key point in distilling those 3 cases.
And that's not about the status of the person in as much as it is the nature of the proceedings. In other words, I mean, it seems to me that if you expand or if you apply Rosenberg to this situation, that we're really saying that any time that you speak to a governmental authority doing an investigation, there's complete immunity, which then doesn't make it a limited doctrine.
Right. I think that...
No, but isn't the difference here that you have human specimens?
Well, I don't think...
We're talking about people's lives and health potentially on the line. This is not like some other administrative
Yeah, but I don't think that is the key point, because you have a vast number of cases dealing with medical malpractice, qualifications, and competence of doctors, and in those cases, consistently from the 1950s through the statutory law, there's that compelling interest is not so compelling that a qualified immunity wouldn't protect the individual.
Let's say in Rosenberg, same fact, same inquiry, the statements made about someone who's not the subject does not have the right to challenge it. But it's the same proceeding. So in that case, would the person making the statement only have qualified immunity because the person they made the statement about isn't able to?
I think that's, yes, that's our position.
How could that
And-
not be a status-based rule?
Well, I think, and by saying it's a status-based rule,
Depends on the person. It's not dependent on the proceeding. It doesn't give you a blanket rule for this proceeding in the U5 in Rosenberg. It just gives you, the immunity is dependent on who you say it about.
there's some truth to that, but I think that this court has made analogous distinctions. So in Front versus Khalil, where the issue was pre-litigation statements of attorneys, you could say that there should be a common rule that all those statements are either qualified or absolutely protected. But the court, your court, did something different than that and said that if the statement was made in good faith and was relevant to anticipated litigation, that's qualified. But if it was not made in good faith, it was not relevant, then therefore it's, I'm sorry, I'm reversing, excuse me, it's absolute, and if it's otherwise, it's qualified. So the court is willing to make those kind of distinctions when such an important principle is at stake as somebody having a right to challenge.
So can I ask, is your position then that the person must be able to challenge in whatever is this quasi-judicial proceeding that we're talking about, versus having an opportunity within the administrative framework to try and get some kind of relief from the agency?
My position is that the
Let
person.
me put it this way. Let's say in this example,
Yes.
I'm assuming for the moment this is not true, you'll tell me otherwise. Let's say hypothetically, that although she could not proceed if there was a hearing to in any way inject herself into the hearing, nevertheless, the administrative framework allows for someone like her, where someone has made a comment that she thinks is false and defames her, to write a letter to the agency seeking for some kind of removal of her name from the record. Would you say in that case, that person still has an action for defamation?
Oh, yes, I do.
Okay. So
And-
even if they're not proceeding under the judicial, in the quasi-judicial proceeding, right? So the administrative adjudicatory arm of the administrative entity.
That's
You would recognize that as long as this person has within this administrative framework some relief, right? Yes?
Yes.
That then the person who spoke would have absolute immunity against the defamation claim.
if that person, like in Toker, Toker made that distinction, and in Toker, it found that the individual, the defamed party, did not have any opportunity at the hearing to contest the defamation, and therefore, there were other factors, but this was the central factor in my view. Therefore, this was not a quasi-judicial proceeding. So,
Can you help me with the following? Maybe you can, maybe you can't. As I understand it, the reason for granting an immunity, whether it's qualified or it's absolute, is to protect, in this case, the investigative process. With me so far?
yes,
Okay. Here, the investigative process is the FDA's process, right?
with you.
I'm sorry?
I'm with you,
Okay. The FDA is a federal agency, right?
right?
Okay. Why does New York law have anything to do with this? Why isn't this governed by federal immunity law? And if that's right, can you point me to anything that would tell me under federal law whether it would be qualified or absolute immunity?
Well, because the action is not against the FDA. The action is against this citizen of New York, and therefore the common law of New York applies.
To the defamation claim, but to the claim of immunity, why would New York law govern that? That would mean if the FDA were investigating this in several different states, its investigative process might be subject to different immunity rules depending on where the particular witness was located?
I think that might be the consequence. I haven't, to be honest, I haven't researched that, but I can tell you that in most states, from my understanding, would apply a qualified privilege here and not an absolute
Or
privilege.
what's the federal rule on it?
I don't know, in truth.
Your time is up, thank you. You'll have your rebuttal.
Okay.
May it please the court, my name is Christopher Porzio, and I represent the defendant's respondents in this matter. I'd like
Counsel, I
to...
just want to ask you up front, is it correct, I believe that's a representation, you'll tell me otherwise when you get back on rebuttal. Is it correct that this plaintiff would not have any recourse in the administrative setting or to somehow protect her reputation, to purge these statements about her?
Well, Your Honor, with respect to that point made by appellant, the only argument that appellant's ever made here is that Ms. Stega specifically doesn't have the opportunity in this particular quasi-judicial proceeding to challenge the veracity of the statements that were made to the FDA investigator. So there's never been an argument one way or the other about whether or not it gives her alternative avenues to clear her name.
Do you know if there are? If
I do-
Dr. Stega has some other way to deal with the reputational harm she alleged has occurred?
I do not, but I think it should be recalled, Your Honor, that the fact is this process and this FDA investigation that occurred here arose out of a complaint that Ms. Stega made in the first place to the FDA. The other point I would make is...
Well, we don't want to chill someone, right? We don't want to discourage complaints.
No, but, Your Honor, my point in making that statement is that having this idea of name clearing and making the application of an absolute privilege predicated on that opportunity to clear one's name creates sort of a perspective,
Well,
or
I think
as
it's-
Judge
I don't-
Garcia
I don't
said,
think it, I don't, to say it clears someone's name is to presume it clears someone's name. I don't think that's the purpose. I think it's to have an opportunity before a neutral fact finder to present or respond to an allegation that you allege is a lie. So, and since the consequences of the decisions of a particular administrative body affect Dr. Stega or someone in her position, the argument is that they should be able to have an opportunity to speak. Here, they don't have an opportunity to speak. That's the way I understand that argument.
Well, Your Honor, with respect to that issue, I think, you know, the court's decision in Rosenberg, the
Let me ask
application...
you this about Rosenberg. You know, we've been talking about it a little bit. Do you think Rosenberg overturns or negates the reasoning in Pollock or Toker versus Pollock?
It negates it to the extent that the Toker holding was based on did not apply the absolute privilege because the statements were not made in an actual quasi-judicial
It
hearing.
doesn't say that in the decision, of course.
In Rosenberg.
Yeah.
It does not say that. But the point, it's the only logical reading of Rosenberg, because Rosenberg holds
So
that
are
statement...
we in a position then that we have to choose between the analysis in Toker or the analysis in Rosenberg? Or can Rosenberg be distinguished from Toker and we can move forward?
Well, I think Rosenberg is an evolution of the absolute privilege in the eyes of this court, based on the fact that as we get into modern society with administrative agencies functioning much more in an adjudicatory process.
Well, wouldn't that mean that the Toker idea that you should be able to speak up where somebody's making a decision about you even more important as we move into that kind of a society?
Well, I think it's the process. I mean, the point of the quasi-judicial privilege here is an extension of the judicial privilege. Statements made in a judicial proceeding are absolutely
Right,
privileged.
right, but these statements weren't made in a judicial proceeding.
No, but my point is, the recognition is that this court's holdings are to the effect that the privilege has been extended to the quasi-judicial context
with that
based on the fundamental aspects of these proceedings that make them judicial
So are
in
you
nature.
suggesting that it's no longer a limited doctrine, it's now, I mean, it seems to me that, as you say, there's such a proliferation of these these administrative agencies. They're everywhere in our lives, and there are all kinds of proceedings, informal and informal and whatever, before these proceedings. And if every time a person is called to speak, in an investigation, is entitled to absolute immunity, then it's no longer a restricted concept. And my question to you, though, is why isn't qualified immunity enough here? Why? I mean, you still have to prove. You'd have to prove malice, right? right? And so why should someone be able to make false statements, defamatory statements about another person to any agency under these circumstances with malice?
Well, because I think it comes down to the policy considerations behind it. And under this court's holdings, in Rosenberg, the court held that the policy consideration of protecting the investing public from unscrupulous and unethical brokers was sufficient to support the application of an absolute privilege over merely a qualified privilege. Similarly, going back to this court's decision in Weiner against Weintraub, it held that the policy consideration of upholding the standards of the bar required an absolute privilege to apply about complaints.
What about the judiciary?
What about, I'm sorry?
Haven't we said in the case of judicial reviewing potential judge candidates that a qualified immunity was sufficient?
Are you referring to the Toker case? I think Toker can be reconciled because this, in reaching its decision, the court in Toker first found that the Department of Investigation had no ability to create a remedy based on its findings, and that there was not the possibility of a hearing. So I think Toker can be reconciled with Rosenberg and the others because Toker stands for the process in Toker wasn't truly quasi-judicial. In contrast here, the FDA had the ability to sanction the hospital IRB and conduct an administrative hearing to revoke the approval.
It couldn't provide any remedy at all to the plaintiff.
Well, that's because the subject of this proceeding was, in fact, the IRB.
And that would argue, I agree with you about that. It is a limitation on the hearing, you're right about that. The problem is that it creates a situation then where in an ancillary hearing, you can do damage to somebody and they can't even confront the challenge to their reputation, or in this case, their livelihood. And it's, you know, Toker had this language about these kind of investigations that Judge Jason used, that's, he talks about it, he said to not challenge it would provide an unchecked vehicle for silent but effective character assassination, is the language that Judge Jason used there. And so ultimately, the question may come down to whether or not the party affected is silent in whatever proceeding that comes up. And I guess, so our question here is she silent here? It seems to me she is, and that's why I'm asking it. You tell me she's not. Tell me how she's not silent.
Well, certainly she wasn't silent with respect to
in the
making the
context of the
complaint and communicating with the FDA with respect to the
No, she
issues that
actually
it was
brought the
investigating.
complaint, right? The original investigation, she brought it.
That's correct.
So, but she won't be heard at any hearing.
No, but, Your Honor, I think the other thing to remember is with respect
Well,
to...
that's not, she might be heard at a hearing. The question
I
is
guess-
not that. The question is whether or not, and I thought you said you don't know, because
I
that was
don't
my
know.
question.
I
Has
don't
she-
know
excuse me.
if she has
Excuse
the
me. Has
right
she got any
to
recourse
intervene in the
within
hearing.
the agency, whether it's at the hearing or otherwise? And I asked both of you, and it seems there's not certainty about this.
Right, but again, in the prior quasi-judicial context addressed by this court, it's the subject of the investigation that has the rights in the quasi-judicial proceeding.
That would be the IRB here, right?
Correct.
Right, it would not be Stega, so she has no rights in this hearing.
Right,
Can
but
she
but
bring an-
in
can-
Rose, the
Excuse me,
reason... I'm sorry.
counsel.
Yes.
Can
I'm sorry.
she bring a complaint to the FDA regarding the statements that were made in this investigation?
Your Honor, I'm not sure if she
No,
could...
okay.
I have a different question, which is in Weintraub, Toker, Park Knoll, Rosenberg, the declarant who made the statements that are at issue were all under oath. Here, the declarant made the statements is not under oath. Does that matter? Does that distinguish this sufficiently from all these other cases?
Your Honor, I'm not sure that's entirely accurate. I mean, with regard to the U5, I mean, it's there's, I guess, some certification language, but it's not a sworn oath, and the person making the statement about the employee on the Form U-5 isn't under oath. It's not notarized and sworn to. And I don't believe, in Weiner, the complaint to the grievance committee was, I believe, via a letter by the aggrieved client against the lawyer. So I'm not sure that it was, all of those statements were under oath. And I would submit it shouldn't make a difference and it shouldn't matter, because the point here is the policy consideration of protecting human subjects involved in clinical trials, which is what the FDA was investigating here in investigating the IRB, is so important that you want to foster absolute candor by those who are involved in that investigatory process. And I think given that policy consideration, the absolute privilege should be applied here.
Thank you, Counsel.
Let me try to address some of the questions you asked. First of all, under Judge Feinman's question, it doesn't matter that there wasn't an assurance of truthfulness because it wasn't under oath, it wasn't a certification, and I say the answer is yes.
Well, but the response, I suppose, could be that lying to a federal investigator is punishable, isn't it not? Even if you're not under oath? I mean, certainly if you're interviewed by the FBI, for example, you can't lie to an FBI agent.
You know, I don't know if that's the case, but the hearing itself before the FDA is, there's no provision in the regulations and the staff manual that it's under oath. There's no provision that the presiding judge can subpoena somebody. There's a provision that says these hearings are informal and that the presiding judge, in fact, can close them to the public. The key issue here, there are two key issues here. One, are the procedural safeguards in place to protect the defamed party? And two, is this a proceeding that's court-like, that has the attributes of a court? And for all those reasons, I'd say, leaving aside the absence of procedural safeguards, it doesn't have those attributes. I'd like to respond to Judge Stein's question about, doesn't the qualified privilege protect the free flow of information? I think I already said that qualified privilege has been applied in all sorts of situations, as compelling as a situation is here. And I think there's no authority cited in any case that the qualified privilege is somehow inadequate, insufficient. There is authority that says that applying the absolute privilege has led to abuses, and that's the First Department's decision in Coconey. And
So what is the rule that you would have us adopt here? We have Rosenberg, we have Toker, and, we have all this. So if we synthesize all that, what is the rule that we should be?
Okay, on a very narrow basis, and I'll get to your question more adequately later. On a very narrow basis, this is not a quasi-judicial proceeding because it doesn't have court-like attributes, and it doesn't have these procedural safeguards for the defamed party. On a more general approach, that a quasi-judicial proceeding has to allow the defamed party an opportunity to protect her reputation. And if there's not in the administrative process, it's unjust to say that she can't go to court.
If I asked you and you said you weren't sure, I understand your point about the possible proceeding, but again, like in this case, there may never be that proceeding. And I asked you, does she have some other recourse within the administrative framework, and you said you're not sure.
Not that I know of. I've read through.
Let me ask you this.
CFR. Can I answer?
No. Did you have to plead that? Did you have to plead that she has no other recourse within the administrative framework? Is the pleading then insufficient?
I don't think you have to plead it, because I don't think the absence of some other complaint proceeding, like writing a letter, rehabilitates the central inadequacy of the FDA inspection process.
No, but if the problem is she doesn't have an opportunity to speak on her own behalf, on her defense, and someone in the agency to measure that, like the administrative law judge or the hearing officer within such a proceeding. But she has a mechanism to file a complaint based on those statements. Would that not meet what you say is some of the concern in the case law?
No, I don't think so, because the damage has been done. And, we're talking about this hypothetical complaint. Does she have the
Well,
opportunity?
what if they expunge everything?
That,
Isn't that her concern?
yeah, but I think this is also, none of this is in the record, and none of this is.
That's why I'm asking you about the sufficiency of the complaint.
Well, with all inferences supporting the adequacy of the complaint, I don't think that this factor would be considered. And I think
also, arguably, wouldn't that really be on them to assert as part of their defense if they're claiming absolute immunity, as opposed to your pleading requirement for your defamation complaint?
yeah, I think that's a very good point.
Well, no, because I asked you before and we were going on about whether or not it's dicta, you seem to suggest that it all turns on whether or not she's got an opportunity in the administrative proceeding to defend herself. So no, it sounds to me like you have to actually plead that. That she cannot.
That in this judicial, I did plead it, and in this proceeding,
But I
this
asked you not-
FD,
but
excuse
yes,
me,
but I've
this
asked, and you
FDA
don't
inspection, she didn't have any of that she didn't have the opportunity.
Yes, but the question was, within the framework of our laws and our decisional law, if indeed she has some other mechanism, not in that hearing process, but within the administrative structure, an opportunity to expunge whatever's this damaging statement and protect her reputation, how does she still have that claim?
That she doesn't, because there's nothing in the CFR, I've read through the manual, that gives her the right. The only way there's a hearing, the only context for a hearing is when the FDA disqualifies an IRB. So there's nothing, there's no evidence, there's nothing to support that contention.
Your light
Okay.
is off.
My light is off.
Do you want to take one moment?
No, I'm
Thank you,
close.
Counsel.
Thank you very much.